Good day to everyone. We will discuss today the Indeterminate Sentence Law. What is the rationale or reason behind the law? In imposing a penalty, the law or the ISL simply mandates courts to fix a minimum and a maximum period of the penalty. This means that after the convict serves the minimum sentence, he becomes eligible for parole. Now, you might ask, what is parole? Parole is the conditional release of a prisoner from a correctional institution after he serves the minimum period of his prison sentence. Now, to be released on parole means that the convict will serve the remainder of his sentence out of prison under the supervision of a parole officer. It is the Board of Pardons and Parole, an agency under the Office of the Secretary of Justice, that grants parole to a prisoner. Now, if a parolee, meaning the person who was given parole, violates the conditions of his parole, then he shall be rearrested and recommitted to prison to serve the unexpired portion of the maximum period of his sentence. So, based on these statements, you now see why the law mandates courts to fix a minimum and a maximum period of the penalty. What is the purpose of the law? One of the purposes is to promote the prisoner's reformation by allowing him to serve sentence outside of prison under the supervision of a parole officer. Another is to decongest the jails, thereby allowing the government to save money. That's a very practical reason. The third one is that the minimum and maximum terms of imprisonment are specified in order to prevent unnecessary deprivation of liberty and enhance a convict's economic usefulness. Now, the maximum penalty is necessary for the imposition of the accessory penalties, while the minimum penalty is important to allow the prisoner the chance for parole. In short, he is given a chance to go back to society and redeem himself. What does this mean? Yes, for every principal penalty, there is always a corresponding accessory penalty imposed. Now, for the duration of his sentence, even if the convict is granted parole, he will have to suffer the accessory penalties until the maximum period of his sentence is served. It doesn't mean that just because he is granted parole, he will no longer suffer the accessory penalties. No. That is the reason why there should still be a maximum penalty for purposes of the convict serving the accessory penalties, or he is made to suffer the accessory penalties until after he finishes the maximum period of his sentence. Now, when is the law applicable? The Indeterminate Sentence Law is mandatory except for the following. Number one, it doesn't apply to crimes punished by death or life imprisonment. It also does not apply to felonies punished by reclusion perpetua. Now, to be clear about it, the Indeterminate Sentence Law doesn't mention of felonies punished by reclusion perpetua. The reason why the ISL doesn't apply to felonies punished by reclusion perpetua is because of Article 63, Paragraph 1, which provides that regardless of the presence of mitigating or aggravating circumstances, the indivisible penalty of reclusion perpetua shall always be imposed if warranted. Second, it doesn't apply to those persons convicted of treason, conspiracy or proposal to commit treason, misprision of treason, rebellion, sedition, espionage, piracy. It doesn't apply to those who are habitual delinquents, those who escaped from confinement or evaded sentence, those granted conditional pardon and who violated its terms, those whose maximum term of imprisonment does not exceed 1 year, and those imposed a non-prison sentence like a fine. Now, to repeat, those falling in any of the above instances cannot qualify for indeterminate sentence, meaning to say, the courts in imposing the penalty will have to apply or impose the actual penalty pursuant to the crime committed. It doesn't have or it won't have a minimum and a maximum term of imprisonment. How does the law operate? We have to distinguish if the crime is a violation of the Revised Penal Code or if the crime is a violation of a special penal law. Now, if the crime is a violation of the Revised Penal Code, the rule is, in order to get the maximum term of imprisonment, the maximum term of imprisonment is the penalty prescribed by the Revised Penal Code for the felony itself, taking into account the attending, aggravating, and mitigating circumstances pursuant to Article 64 of the Revised Penal Code. This means that the modifying circumstances, the mitigating and aggravating circumstances, are first considered in determining the maximum penalty or maximum term of imprisonment. Now, to get the minimum term of imprisonment, the law provides that it will be put within the range of the penalty next lower in degree than what the Revised Penal Code has prescribed for the felony committed. Now, take note that the modifying circumstances I mentioned a while ago do not apply or have no bearing with respect to the determination of the minimum penalty or the minimum term of imprisonment. So, whenever you encounter mitigating or aggravating circumstances, always apply that or take them into consideration with respect to arriving at the maximum term of imprisonment and never with respect to getting the minimum term of imprisonment. Let's go through some illustrations for your better understanding. Example number 1. In the crime of homicide, the penalty is reclusion temporal as a whole. That is the penalty imposable in the Revised Penal Code or the penalty prescribed for the felony committed. Now, which period, minimum, medium, or maximum, should we place the maximum term of the indeterminate sentence? Answer, pursuant to Article 64, when there is no mitigating and no aggravating circumstance, the maximum term of the indeterminate sentence should be placed at the medium period. Thus, the maximum term should be reclusion temporal in the medium period. Now, to get the minimum penalty or the minimum term of imprisonment, the rule is to simply get the penalty 1 degree lower from the penalty imposable without taking into account the mitigating and aggravating circumstances. Hence, the penalty 1 degree lower from reclusion temporal is prisión mayor. Prisión mayor as a whole is now the minimum term of the indeterminate sentence in the above example. but prisión mayor is a divisible penalty. Which period can it be placed? The answer is it would depend upon the discretion of the court on which period to place it. Thus, the minimum term of the indeterminate sentence is prisión mayor in any of its periods, whether minimum, medium, or maximum. The court will then impose upon the convict an indeterminate sentence of prisión mayor in any of its periods as the minimum term of imprisonment to reclusión temporal medium as the maximum term of imprisonment. To be more specific, the court, in its discretion, can impose a prison sentence of, let's say, 9 years as minimum to 17 years as maximum. Or it could be as short as 6 years and 1 day as minimum to 14 years, 8 months, and 1 day as maximum, and so on and so forth, for as long as the number of years imposed by the court is within the range of prisión mayor or within the range of reclusión temporal medium pursuant to the example. Example number 2. Suppose in the example above, one aggravating circumstance was proven. What is now the maximum term of imprisonment? Answer, it would still be reclusión temporal, but it shall be placed in the maximum period because of the presence of one aggravating circumstance. How about the minimum term of imprisonment? It would still be 1 degree lower from reclusión temporal, which is prisión mayor. In which period? It shall be discretionary upon the court. Meaning to say, the court can impose a penalty within the range of prisión mayor. And prisión mayor has a range of 6 years and 1 day to 12 years. So, the court can impose a prison sentence of 9 years as minimum to 20 years as maximum. Or it could be as short as 6 years and 1 day as minimum to 17 years, 4 months and 1 day as maximum, depending, as I said, on the court's discretion. Example number 3. Let's say there is one mitigating circumstance but no aggravating circumstance. In such a case, the maximum term will be reclusión temporal in the minimum period because of the presence of the said mitigating circumstance, and the minimum term shall still be prisión mayor in any period. Again, you will notice that the modifying circumstances affects the maximum term only. It doesn't affect the minimum term. Or if there be two mitigating circumstances, two ordinary mitigating circumstances with no aggravating circumstance, or what if there is a privileged mitigating circumstance, the maximum term will then be prisión mayor in the medium period. Why? Because the presence of two mitigating circumstances, ordinary mitigating with no aggravating, or the presence of a privileged mitigating circumstance mandates the courts to lower the penalty by 1 degree from the penalty prescribed by law for the offense. So, in that example, homicide has a penalty imposable of reclusión temporal. 1 degree lower of reclusión temporal is prisión mayor. Now, why is it prisión mayor in the medium period? It's because if there be no other mitigating circumstances left and there is no aggravating circumstance also, then the proper period should be placed in the medium. That's why what you see here is prisión mayor in the medium period. Now, the minimum term should be 1 degree lower after considering the privileged mitigating circumstance, or after considering the presence of two mitigating circumstances with no aggravating circumstance. So, since the maximum term is prisión mayor, then the penalty 1 degree lower should be prisión correctional in any period for purposes of arriving at the minimum term of imprisonment. Take note that if there is a privileged mitigating circumstance, or if there are at least two mitigating circumstances without any aggravating circumstance, we take it into account first in order to obtain the proper maximum penalty or maximum term of imprisonment. Then, from that maximum penalty, we obtain the proper minimum penalty or minimum term of imprisonment by getting the penalty 1 degree lower. The same rule applies as to the period of the minimum penalty. Also remember that even if there are two or more ordinary mitigating circumstances present, it will never lower the penalty by 1 degree if there is an aggravating circumstance present. For example, the accused was able to prove 8 ordinary mitigating circumstances, but the prosecutor was also able to allege and prove at least 1 aggravating circumstance. Here, the penalty can no longer be lowered by 1 degree. But if it is a privileged mitigating circumstance like minority, or it could be a privileged mitigating circumstance of incomplete justifying or incomplete exempting circumstances, it will always lower the penalty by 1 degree even with the presence of an aggravating circumstance. This is the distinction between an ordinary mitigating and a privileged mitigating circumstance, because in a privileged mitigating circumstance, it will always lower the penalty by 1 degree, regardless of the presence of an aggravating circumstance, but not so with respect to ordinary mitigating circumstances. Another example. There are 3 mitigating circumstances and no aggravating circumstance present. The effect is the maximum term will be prisión mayor in the minimum period, and the minimum term will be prisión correctional in any period. Why is that? There are 3 mitigating circumstances present, right? And no aggravating circumstance. The first 2 mitigating circumstances shall lower the penalty by 1 degree. So from reclusión temporal, we now have prisión mayor. Thus, the penalty will be reduced by 1 degree from reclusión temporal to prisión mayor. The third remaining mitigating circumstance shall place the penalty in the minimum period. So, that is why you now have prisión mayor in the minimum period as the maximum term of imprisonment. The court cannot lower the penalty by 2 degrees even when there are 4 or more mitigating circumstances and no aggravating circumstance, because the law allows only a 1 degree deduction no matter how many mitigating circumstances are present. How does the law operate in case of a complex crime under Article 48? Example number 1. Let us assume, for example, that the offender was convicted of the complex crime of estafa through falsification of a public document. under the Revised Penal Code, falsification of public documents, Article 171, is a more serious offense punished by prisión mayor than estafa, punished only by prisión correccional. So the answer is, applying the Indeterminate Sentence Law, the maximum term of imprisonment for estafa through falsification of public document shall be prisión mayor in the maximum period. Now, the minimum term shall be 1 degree lower, which should be prisión correccional in any period. Example number 2. Suppose there was one mitigating circumstance proven. The maximum term of imprisonment will still be prisión mayor in the maximum period. Why is that? It is so because under Article 48, even if there is a mitigating circumstance present, the penalty should still be imposed at the maximum period. The minimum term shall be prisión correccional in any period, similar to example number 1. Example number 3, how about if there are two mitigating circumstances and no aggravating circumstance? Or how about if it is a privileged mitigating circumstance? In such a case, the rule is lower the penalty by 1 degree, prisión mayor, lowered by 1 degree is prisión correccional, but still place it at the maximum period. Thus, the maximum term of imprisonment shall be prisión correccional in the maximum period. Accordingly, to get the minimum term, lower it based on prisión correccional. And what is 1 degree lower of prisión correccional? Arresto mayor, such that the minimum term shall be arresto mayor in any period. Now, if the crime is a violation of a special law, what is the rule? This is how you get the maximum and minimum terms of imprisonment. The rule is the maximum term should not exceed the maximum provided by the special law. The minimum term, on the other hand, should not fall below the minimum provided by the said law. In other words, the maximum term cannot exceed the maximum that the law in question has prescribed, whereas the minimum term cannot be less than that prescribed minimum. For example, if the penalty imposable is 6 to 12 years, the court, in its discretion, may impose a prison sentence, let's say, of 6 to 12, or 7 to 11 years, or 8 to 10 years, so long as it does not go outside of the range of the imposable penalty prescribed by that special law.